Good morning, everyone, and welcome, or I guess afternoon by now. Thank you so much for joining me. We do have a lot of information to cover regarding the contract changes for NABOR. What you can see on your screen are the NABOR legal hotline. If you call that hotline, you'll receive a referral to one of the attorneys who serves on the Legal Resources Committee. You can imagine we have met quite often over the past few months to review or revise these documents to ensure compliance with the proposed NAR settlement. So we have got the phone number for the legal hotline. Also, you've got the phone number for the Florida Realtors legal hotline with respect to any of the Florida Realtors forms. So what I'm going to go ahead and do is go back to our initial slide on our PowerPoint. I want to tell you a little bit about where we're starting. So bear with me a moment. We're getting to page 1. Okay, so we are starting with a few assumptions. One, the assumption is that the forms that have been revised, I'm assuming that you're relatively familiar with the form, that purpose, and then the forms that are brand new, we're going to talk about the purpose of the form, and then again, recognize that these are tools in your toolbox that you're welcome to use in your business practices. Consult with your broker, consult with counsel as to how they would like for you to use these forms. But again, these are resources that will be available to you. The forms that we're going to talk about today are all uploaded onto NABOR.com, so you will have access to them at NABOR.com, even if they're not yet available with your vendor, whether you use Form Simplicity or AppFiles. They are all available on the NABOR.com website. All right, so you should have received an email with 2 packets. The first packet is with respect to the red lines, the first set of documents that were released about a week or 2 ago, and then the second packet of brand new forms that we're going to discuss. So let's go through what we're going to talk about, and then we'll talk about the actual meat and potatoes of this presentation. In the first packet, there is the listing of residential improved property, exclusive right and authority to sell. This is not a new form. This is a revised form. So we revised it to make sure it complies with both the letter and the spirit of the NAR settlement. Number 2, the buyer-broker agreement exclusive. This form did exist in the library, but it wasn't very commonly used. So we did update it and revise it again for compliance purposes. Number 3, the amendment to buyer-broker agreement. That is a brand new form. It is a blank slate form, but I would encourage you to discuss with counsel before you start drafting legal language to put in the amendments. Number 4 is the showing agreement or showing compensation agreement, no brokerage or agency relationship. That is an old form that existed in the NABOR library. It has been revised to ensure compliance. That is a scenario where you might have a for sale by owner, seller, and the broker who procures a buyer would like compensation for that. Number 5 is the broker compensation agreement. That is between brokers, a broker, listing broker to a buyer broker. That compensation agreement is the documentation that you would need if you're expecting compensation from a listing broker to your buyer's broker for services on behalf of a buyer in your transaction. Number 6 is the new construction broker services disclosure form. Again, a form that already existed in the library that has been updated to comply with the rules regarding disclosure of broker compensation. This form, if you use it for new construction, know that you will also still need a buyer broker agreement. It's just related to some of the services you may provide on behalf of a new construction buyer. When we get to the second packet, we'll talk about the amendment to the listing contract regarding compensation and concessions and the broker compensation disclosure. These 2 forms really have a limited lifespan because they're designed to bridge the gap between your current listings or current transactions, your current listings, and bring them up to speed in compliance with the disclosure requirements. Number 3 is the amendment to broker compensation agreement. Again, we looked at number 5 above. There's a broker compensation agreement between brokers. If that needs to be modified, we have an amendment form for the parties to use to amend that broker compensation agreement. And also brand new is an addendum to sales contract related to concessions, brand new form just approved last week by the Legal Resources Committee for use in your sales transactions if the buyer and the seller would like to agree to a credit or concession for closing costs, prepaid, that kind of thing. All right, we're going to dive right into the first document. I'm going to show the documents on the screen, but I want to tell you sort of what overall this listing format was updated to do. it revised the word cooperating or selling to buyer's broker. So throughout the entire forms library at NABOR, you'll see as these forms are released that the word cooperating broker or selling broker has been changed to buyer's broker. On some of the forms, that might be the only change that exists, but in other forms, just note that cooperating or selling will now be considered buyer's broker. Also, we included that compensation disclosure language. I'm calling it the big bold language that's required. It also allows sellers to offer concessions. We'll talk about that. It requires sellers to provide association information and also includes a mailing address for the brokerage for notice requirements. All right, I'm going to switch gears real quick and go ahead and pull up that listing agreement, and we'll talk about that. And I recognize that the listing agreement is, the print's kind of small, I will admit. Hopefully you can see it here on your screen. And then when we get to paragraph K, the compensation paragraph, I will show you a slide that has the clean copy. And it really does look nice. The red line looks a little difficult to read. All right, so we are all on the same page now. We've got the listing of residential improved property, exclusive right and authority to sell contract. Go with me down to the very first paragraph, line 5. We've added language regarding the seller giving the broker the authority to list, market, sell, and procure a buyer of the real property. Some of the other changes in line 7 are just some grammatical or changes that don't really affect the substantive information in the contract. So just know sometimes we capitalize or remove caps when the item is not defined. So I'm going to scroll down to line 22 because that is an important change. So the termination date, the default termination date under this listing agreement shall actually be 365 days if there is no termination date inserted. So look at line 20, we've got a commencement date of our listing agreement and then the termination date. You have an opportunity to insert your termination date. If you do not include a termination date, then the default termination date will be 365 days from the commencement date. So again, where there's a blank line, make sure you're reviewing, inputting the information, but we do have a default provision of 365 days if you forget to put a termination date. We're going to go down to the line 45. Again, the broker's obligation is to make an earnest and continuing effort to sell the property and procure a buyer. And you'll note on all the new forms, you'll see the footer has the revision date. Make sure you're working with the most up-to-date forms as they become released. So these forms, you'll look for a note of 2024. And this, of course, was approved July 12th, 2024. We're scrolling down to the line 51 to 54. Again, under obligations of our seller or our broker is to distribute information about the property, invite the cooperation of other brokers to procure a buyer of the property. In the event a buyer is procured by another real estate broker, we're calling them now, again, the buyer's broker, not cooperating broker, the buyer's broker. The listing broker will assist the buyer's broker to complete the sale, and if elected in the compensation paragraph 4K2D1, will compensate the buyer's broker as provided in the listing contract. And we'll go down to paragraph 4K in just a moment. So again, throughout the form, we're removing cooperating and changing it to buyer's broker. It might take a little bit for us to adjust our lingo, but again, that has been on all of our forms updated. All right, paragraph 4K. We're on line 123. If everyone can see where we are at line 123, and below, we're looking at the purple revised language. Again, the purpose of this revision was to ensure, one, that we have the big bold language in 124 and 125. It says compensation paid to a real estate broker and or any broker commissions are not set by law and are fully negotiable. That big bold language you'll see in all of the documents related to compensation. So with me on line 126, the seller shall pay a total compensation, which we've defined as capital C compensation, to the broker if a buyer who is ready, willing, and able to purchase a property is procured. And then you've got options to check a box as to the type of compensation that the seller will offer to the listing broker. On line 28, you see a percentage of the purchase price and blank a dollar amount. So perhaps if you've got a transaction broker fee, that dollar amount could go there. Or if you charge just a straight fee, you'd insert the dollar amount that the seller would be obligated to pay the listing broker, or some other type of compensation or commission due to the broker. That's in line 133. Also, we've got the broker has explained to the seller, that's the top of paragraph 2. I'm scrolling down to line 140. Go with me to 140A. You can see that here. So this broker has explained to the seller that if the seller offers to compensate a buyer's broker who has procured the buyer, we've defined them as buyer broker compensation, that amount of money that the seller may offer to a buyer's broker, such buyer broker compensation will be deducted from the total compensation defined above, with the broker retaining the balance of compensation to be paid by the seller as set forth herein. So we've got total compensation up in paragraph 1, and then if the seller opts to offer buyer broker compensation, that buyer broker compensation amount in this subparagraph will be deducted from that total compensation, and then the listing broker will retain the balance. So with me to line 146, that's 2B, that buyers, agents, and brokers, even if compensated by the broker or the seller, may represent the interests of a buyer. That makes sense. Also not new language. Also, number 3, that a buyer broker compensation is not set by law and is fully negotiable, and that seller is not required to make an offer of compensation to buyers, brokers, or other buyers' representatives. Again, we want to make it clear if the seller is opting in to pay compensation to a buyer's broker, we're allowing them to review this form and opt in to elect to pay the buyer's broker compensation. Line 149. We've got 2 check boxes below. Seller elects the following, and if they make no election, meaning forget to check a box, then it is deemed as if the seller did not elect to offer compensation to a buyer's broker. So again, have a conversation with your seller. They elect to permit the broker to offer a share a portion of the compensation with a buyer's broker who's procured a buyer. You would check the box in line 150, that's subparagraph 1. Upon receipt by the broker, again, the listing broker, of that total compensation as provided in paragraph 4K1, the broker will pay the buyer's broker, and then the seller gets to elect how much money they'd like to offer to the buyer's broker. In line 154, it is a percentage of the purchase price or a flat fee. Go with me to 155 and 156, or some other form of compensation. So again, this amount in 155, 156, and 154 would be deducted from the total compensation listed in 4K. So I think it's probably a good idea to go back to my screen to share with you the slides that I have on paragraph K. So this is paragraph K in its final form. It is beautiful, if I do say so myself. It is a beautiful form that is easy to read. We can go through it to review exactly what we just talked about in that red line. So line 123, broker compensation, 124, 125. We've got the big bold language that is, we've got the big bold language that is required by the settlement. Again, 124 and 125. All of that language is required. Compensation paid to a real estate broker and or any broker commissions are not set by law and are fully negotiable. We know that. Now our clients also, customers also know that. Line 126, the seller shall pay a total compensation to the broker. Again, here it's referencing the listing broker. If a buyer who is ready, willing, and able to purchase the property is procured. Again, we've got our 3 check boxes. This is the total compensation that's going to the listing broker. The seller, 128, 129, and 130. The seller gets to select what they'd like to pay total to the listing broker. We've got those broker explanations to our seller. Review them with your seller. It also has in line 136 the language, that big bold language, that buyer broker compensation, also not set by law, also fully negotiable, and sellers not required to make an offer of compensation to a buyer's broker or other buyer's representative. And then we get to the question where we get to ask the seller, do you elect to offer buyer broker compensation, or do you not elect to offer buyer broker compensation? So go with me to line 138 of what you see on your screen. We're reviewing those options with our seller. They either are going to select the box in line 139, or they'll select the box in 145. If you forget to make a selection, it's as if line 145, that box next to subparagraph 2 is checked. that they do not elect to permit the broker to offer a portion of the compensation to the procuring buyer's broker. Okay, so in the event the seller does elect in line 139 to permit the broker to offer to share a portion of the compensation with the buyer's broker who has procured the buyer, then upon receipt of that total compensation, the listing broker will pay to the buyer's broker the amount negotiated in line 142, 143, and 144. This is your seller's decision. If they'd like to offer compensation to a buyer's broker, they have the opportunity to do that. So again, this is the major change to the listing form. It looks much better than the red line does. This is our form that we are working with. I'm going to go back to our red line so we can finish up this form, and then we'll move into the buyer broker agreement. Okay, the next section I have here is line 172 to 173. Here, the seller has the opportunity to elect to offer concessions. Think of concessions as credits in a sales contract, concession from seller to buyer. So the first option is seller does not elect to offer a concession to a buyer, or they do elect to offer a concession to a buyer in the amount of, and you either insert a dollar amount or a percentage of the purchase price that goes towards the buyer's closing costs and prepaid. And we've defined that again as a seller's concession, which amount may be used toward the payment of compensation to a buyer's broker. If no selection is made, then does not elect to offer concession to a buyer is what applies, right? So this section is new, offering a seller concession. If the seller wants to offer a credit to the buyer at closing for its closing costs and prepaids, we have an option for the seller to offer a concession or elect not to offer a concession. If they elect to offer a concession, you need to input in line 173 the dollar amount or percentage of the purchase price that the seller is allowing you as the listing broker to offer to as part of the negotiation. Okay, also line 176, broker compensation, that big bold language we see again, broker compensation is not set by law or policy and always fully negotiable. We're also asking the seller, this is a new paragraph, but not a new idea, to provide accurate and current information for any association governing the property. We all know how challenging it could be sometimes to receive this information from our customers to be able to provide it to the buyer. So we're adding in the affirmative obligation for our sellers to provide accurate and current information for any association governing the property. Go with me to line 184 and 185. This is just additional language that appears. It's very similar to what you see in standard E of the sales contract between buyer and seller. We're saying that the seller will agree to pay for and provide verification of the compensation. And if elected under paragraph 4K2D regarding buyer broker compensation, verification of any buyer broker compensation. So again, this information is going to be critical for your closing agents to have, not only the total compensation that the listing broker is entitled to receive, but also if any of that total compensation that the listing broker is entitled to receive is going to pay a buyer broker. That information is very important. Your closing agents and title companies and law firms, if they don't ask better questions, not just how much you're entitled to be paid, but also from whom, make sure that you're providing that information to them, because they're going to need to know that in order to properly allocate on your settlement statement who's providing broker compensation, whether it's a listing broker or buyer broker side. So with me to line 194. Again, we added a seller concession opt-in for our sellers to elect to pay seller concessions. So this is just language reflecting that at closing, the seller will pay any seller concessions that they've offered to the buyer. All right, that's it for the substantive changes there. Also, we're asking the seller to provide at the seller's expense all current association property management company contact information and any required application forms. Again, it's critical the sellers have this access to this information to get the information over to the buyers so they can make application to the association. So having that information regarding the property management company or association contact info is critical. So we're giving the seller the opportunity to provide this information to the buyers so they can make application in a timely manner. All right. Line 247 to 255, just some sort of grammatical changes, nothing substantive here. We did have a line 274, this listing contract will be binding on and near to the benefit of the parties, their heirs, successors, and assigns. So let's move to line 286. This impacts our brokers. It says notices required to be given under this listing contract will be given in writing, not text message, will be given in writing using the contact information below. And also notice to a sales associate will not constitute notice to the broker. So what we've added below, I'm going to scroll on down so we can see what we're talking about. We've added not just the brokerage firm name, but also the broker's mailing address and the broker's phone number, broker's mailing address and phone number. So if there's official legal notices that need to be provided, let's say from a seller or a seller's attorney to the listing broker, to be provided to the broker's mailing address and include that broker's phone number. We also want to make sure that you're getting this information from your seller's contact information, mailing address, that kind of thing. Okay, one more change here to the listing agreement, and we're going to move on to the next form. We added, a while ago, we had added the wire fraud advisory. It used to be below the signature lines. Now we've moved it up to accompany the rest of the important notices and disclosures in this listing agreement. So now it appears as paragraph 12. Paragraph 13A, you've got other terms and conditions. As an attorney, I get a few heart palpitations when I see folks typing in information and other terms and conditions without reviewing it with their broker or by counsel. Just be careful if you need to include other terms and conditions, especially if you're binding your brokerage to something, make sure you've got your broker's thumbs up or a broker's counsel approval. All right, that is the only change here to our listing agreement. We're going to dive into our buyer-broker agreement. So that's the second form in that first packet that we talked about. All right, I'm making some assumptions that this form, though this form has existed in the NABOR library for a while, it may be new to your practice. So we're going to go through not just the red lines, but we're going to kind of go through each of those paragraphs. We talk about what they do, what the parties' obligations are, and then we will again highlight the changes in paragraph 5. This buyer-broker agreement is entered into between the buyer and the broker. Broker meaning brokerage firm name, brokerage name. Paragraph 1 indicates the broker's role, what the broker is going to be doing on behalf of the buyer, and it's with respect to the acquisition or right to use residential real property. So that is a change here. We've added residential real property. Also in the broker's role, the paragraph C, make brokers' best efforts to identify, locate, and tour properties suitable to purchase for the buyer. We're going to assist the buyer in presenting and negotiating contract offers on the properties and monitor contract and closing deadlines. These are collectively defined here as the broker's services, capital B broker, capital S broker's services. These are things that you already do on behalf of your buyer. You're just putting it into a contract between your brokerage and the buyer, setting forth what you are going to be doing on their behalf and for which you will be compensated at closing. Paragraph 2, regarding the brokerage relationship, the broker or the licensee of the broker has informed the buyer of their type of brokerage relationship that exists. What used to exist was a blank line where you'd have to write in the type of relationship. Now we've got checkboxes where you can select transaction broker, single agent, or no brokerage relationship. If that section is left blank on accident, the transaction broker relationship will apply. So paragraph 2, you get to check a box now as the type of relationship that you will have with your buyer. Paragraph 3, because we want to make sure our buyer understands their obligations under this agreement, we're explaining the buyer's role. A buyer agrees to, during the term of this agreement, work exclusively with the broker. This buyer is working exclusively with the broker to evaluate and view properties exclusively with the broker, not with any other broker, licensee, or owner, or builder. The buyer is agreeing to refer to the broker any inquiries from anywhere and from any source regarding any potential properties for sale or lease. The buyer is agreeing to provide reliable information regarding their financial ability to perform under the agreement. Buyers agreeing to provide the broker general information regarding location, price range, amenities, anything that there would be helpful in the broker identifying properties for the buyer. And the buyers agreeing that on all occasions, they're going to notify other brokers, other third parties of the existence of this agreement and the broker's exclusive relationship with the buyer. This is critical for our buyers to understand that when they enter into an exclusive buyer-broker agreement, no matter what, they're agreeing to work exclusively with a particular broker for a particular period of time to look at a particular geographic region or type of property. So we want to make sure that when we ask the buyer to review this information, we're asking them also, have you signed one of these before? Have you signed an exclusive buyer-broker agreement? And ask some follow-up questions because we want to make sure that you are not going to be second in line with the buyer-broker agreement. Okay, paragraph 4, we've got our term of agreement. Similar to our term of agreement on all of our other forms, the term allows the broker the exclusive right and authority to negotiate either for the purchase or lease or other acquisition of any property during the term of this agreement, which commences on X date, commencement date, and will terminate on the termination date. We've got some default provisions in case you accidentally leave those blank. The commencement date will be the date the agreement is signed by the buyer if there's no commencement date inserted, and the termination date default will be 180 days after the commencement date if there is no termination date that is inserted. Again, the term of your agreement, the time period, is negotiable between you and your buyer. Insert the commencement date and the termination date, and if not, there is a default. There's also a protection period. If during the blank day, we've got a 90-day default protection period. So if during the protection period after the termination date, the buyer enters into a contract to purchase or lease any property toured by buyer during the term of this agreement, then the buyer will pay the broker's compensation as set forth in paragraph 5, and the agreement will be automatically extended until the closing or termination of the said contract for sale or lease. This means you've got a protection period after the termination of this buyer-broker agreement, that if the buyer enters into a contract during that protection period for property that they toured during the term of the agreement, then this agreement is extended and buyer will be obligated to pay broker compensation during that time. So another question you may want to ask when you ask a buyer, have you signed a buyer-broker agreement, is also, if it is terminated, your original buyer-broker agreement, is there a protection period that might protect an original buyer-broker's compensation? All right, paragraph 5 is where the bulk of the changes occurs. So we're going to go to paragraph 5, and then I'll show you on a slide the clean version. All right, broker compensation, big, bold language. Real estate broker or any brokerage compensation is not set by law and is fully negotiable. We're saying the broker here in this form is the buyer's broker shall receive the compensation for broker services as follows. And you'll have 3 checkboxes. The checkboxes will be a percentage of the purchase price, a flat fee, or some other kind of compensation. Or in the event that there's a lease and you want to negotiate compensation, in the event your customer enters into a lease instead of a purchase agreement, you've got paragraph B, for each property leased by the buyer as tenant. You've got a checkbox for the percentage of the gross rent and, for example, a transaction fee or a fee of blank dollars or some other compensation. Again, this is for a property that is leased. Paragraph 5, the bulk of this paragraph, it is, there's a lot of language here that would probably be better if we reviewed it all together in the clean copy. So I'm going to go ahead and share that screen again. Bear with me a second so we can see it. This is, again, the bottom of paragraph 5 in your packet. It's a clean version that does not have all the red lines. That is a little bit distracting, but we're going to go through this whole paragraph together. All right, paragraph 5. Compensation shall be deemed earned on any property that is purchased or placed under contract or leased by buyer or anyone on behalf of buyer, irrespective of whether buyer's broker actually showed, located, introduced, or wrote any offer of contract with respect to any property under the terms of this agreement. Compensation will be fully payable upon the earlier of closing, buyer's right to occupy or control the property, or upon the event of a buyer's default under any contract to purchase or rent the subject property. Just a point of clarification, default does not mean ability to terminate under a contingency or inspection provision. Okay, default is buyer gets cold feet at the closing table and they decide not to close. Compensation under this buyer broker agreement would still be due. Buyer will be responsible. I'm in line 5. Buyer will be responsible for the compensation to be paid to the broker, again, between buyer and buyer's broker, provided, however, buyer's broker is authorized to negotiate for a seller or a listing broker or a landlord to pay all or a portion of that compensation. Buyer and broker acknowledge that the seller may offer a credit to the buyer at closing towards the buyer's closing costs and prepaid, which we defined as seller's concession. Buyer agrees that if a seller's concession is provided and the seller, listing broker, and landlord is either not offering compensation to the broker or the compensation that's being offered by those third parties is less than the compensation that is due under this buyer broker agreement, then the buyer's agreeing that the seller's concession could be used or will be used towards the payment of the broker's compensation due under this agreement. Okay. If any amount, I'm no longer in the bold language, we're starting with if any amount paid by a seller or listing broker or landlord to the broker and or seller's concession is less than the compensation to the broker under this agreement, buyer will pay the difference to the broker upon the earlier of closing, buyer's right to occupy the property, or upon the event of a buyer's default. In no event, back to big bold language, will broker be allowed to accept compensation from any source that exceeds the amount of compensation agreed to in this buyer broker agreement. Okay, so here's the sort of how this is going to play out. You enter into a buyer broker agreement with your buyer for compensation of X. This agreement allows you to negotiate to receive a portion or all of that compensation from the listing broker or from the seller. If they agree to pay all of the compensation that's due to you as a buyer's broker, if they agree to pay X, then great. That the buyer's obligation will just be fulfilled when that payment is made at closing. If the seller or listing broker is only willing to pay a portion of X, meaning Y, then the buyer would be responsible for paying the difference at closing between X, meaning the total broker compensation here due to the buyer's broker, and whatever it is that the seller or the listing broker is offering. Okay, but in no event can the buyer broker receive compensation in an amount that exceeds this buyer broker agreement. Again, the amount in paragraph 5. Okay, that language is directly from the proposed settlement. Now, paragraph 6, real quick before we go back into the red line, this agreement is only applicable to residential real property in the following counties in Florida. So you get to define the scope and geographical scope of your relationship. If there's nothing listed in paragraph 6, the default is that this agreement will cover Collier, Lee, and Charlotte counties. You only intend to work in Collier County and you only want to work in Collier County, then of course you can define the geographic scope of your relationship with the consumer. All right, let me go back just real quick. This is what the top of paragraph 5 looks like in its clean version. Again, you've got the check boxes for the buyer to negotiate with the buyer's broker the compensation that would be due in the event of a purchase. That's paragraph 5A. A percentage of the purchase price and a flat, a fee for transaction services, or a fee of blank, or some other type of compensation. And then there's another set of checkboxes if there is a property that is leased by the buyer as a tenant during the term of this agreement and you would like compensation for that, then you can negotiate, again, the percentage of the gross rent and a fee, or a fee of blank dollars, or some other compensation. Okay, I'm going to move on to paragraph 7, default. So that, again, the event of a default is different than an ability to terminate under a contingency, okay? But in the event of a buyer default, I'm on paragraph 7 of the red lines of that buyer-broker agreement. If buyer defaults under any contract to purchase or rent the property or otherwise breaches this agreement, meaning this buyer-broker agreement, will not be terminated, but will continue in full force and effect, and broker shall have all remedies under the law to enforce this agreement. That's up to your broker to determine how they would like you to proceed in enforcing this agreement, so have that conversation with your broker. If the buyer fails to timely pay compensation upon closing, buyer hereby grants the broker the right to place the lien upon any applicable property or properties purchased or acquired, or the rent income accrued from any property or property subject to this agreement, which lien can be foreclosed in the same manner as a mortgage or security instrument placed upon the real property, and which lien shall survive termination of this agreement. So we all know under Chapter 475, a broker cannot place a lien on a customer's property for compensation unless the consumer agrees to in writing. If the buyer defaults and fails to pay broker compensation upon closing of a particular property, the buyer is granting the broker the right to place a lien. Now, again, discuss with your broker the process for pursuing enforcement of the buyer-broker agreement, but just because this language is in our buyer-broker agreement, it does not 100% does not give you, the real estate licensee, the authority to run down to the clerk's office and file a lien on property. You do not have the authority to do that. That is not how that works. But just know that under the default provision, you can work with your broker regarding enforcing the buyer-broker agreement, that in the event of a successful lawsuit that results in a judgment, perhaps that judgment could be filed as a lien on the property after it is purchased and after the broker is not compensated. Again, discuss with counsel on that point. Paragraph 9, we've got fair housing, our fair housing section. That section was not revised, but we do have the opportunity for a buyer to self-select away from properties where a seller's concession is not being offered. So go with me to the paragraph 9, halfway down. Broker will show buyer properties regardless of any seller concession being offered in connection thereof. Buyer elects or declines to be shown property where no seller concession is being offered in connection with the sale thereof. So again, you define seller concession as a credit from seller to buyer towards closing costs and prepaids. In this paragraph, the buyer has the opportunity to elect to be shown properties even if no seller concession is being offered, or declines to be shown properties where no seller concession is being offered. That's the new paragraph 9. Paragraph 10, we've got our litigation and attorney's fees, just some cleanup language confirming that the laws of the state of Florida will control the interpretation and enforcement of this agreement. Venue will be in the county where the property is located. And importantly, prevailing party shall be entitled to recover attorney's fees and court costs from the non-prevailing party, meaning if the broker wins in a dispute with the buyer, they're entitled to recover reasonable attorney's fees as the prevailing party, and vice versa. If the buyer was a successful party in the event of litigation, they would be entitled to prevailing party's attorney's fees. All right. Continuing to paragraph 12, there are some miscellaneous provisions. In the interest of time, I suggest that you review them on your own. Paragraph 12 is miscellaneous. Paragraph 13 is dealing with wire fraud. Again, we kind of move up those provisions to above the signature lines so that we can make sure that the buyer has read them before they sign on the dotted line. Paragraph 14 gives you the opportunity to insert in other terms and conditions. Again, in conjunction with consultation of your broker and counsel, you can put language in here if you'd like some additional provisions. But again, because your broker is going to be responsible for this, make sure that you include this in other terms and conditions with the blessing of your broker. Here we've got their signature lines, again, buyer signature, buyer's printed name, their mailing address, contact information, and we also have the authorized broker's signature, spelling the broker's mailing address, the brokerage firm name. Okay, so here, sorry, I've got a call coming in. So here on our form, just note that we've got the broker's mailing address. Again, insert the brokerage firm name and the brokerage mailing address. That'd be very important. And also have a discussion with your broker as to who should be signing both our listing agreements and the buyer broker agreement. Some brokers may authorize the licensee to execute some of these forms on behalf of the brokerage. Others may require a broker or broker manager to sign these forms. So again, consult with your broker how they'd like you to execute these forms. Okay, I'm scrolling down to an easy breezy form that is easy breezy because it is blank, but again, because this is language that would be binding upon your brokerage and binding upon the buyer, I would strongly urge you to get whatever you want to put in this amendment to the buyer broker agreement approved by counsel. So this is an amendment to the buyer broker agreement between buyer and broker, and the agreement is amended as follows. So input the language here regarding the regarding whatever terms they'd like to amend in the buyer broker agreement, whether it is compensation, whether it is the term, whether it's a protection period or something. But again, opportunity to amend your buyer broker agreement using this form. It also has the big bold language signed by the authorized broker, brokerage firm name, licensee printed name, and we've got our buyer's signatures. All right. We also have our showing agreement, a showing compensation agreement for sale, no brokerage relationship. This is an old form that existed in the library, but it has been heavily modified. And so I will go through a couple on a slide, the middle section that is not highlighted. So paragraph 1, both this is entered into between the seller and the broker related to the seller's property. Paragraph 1, seller will allow the broker to show or market the property for a purchase price of blank and attempt to procure for seller a buyer on terms satisfactory to the seller, and seller is acknowledging receipt from the broker of a notice of no brokerage relationship. I would imagine using this form in a for sale by owner scenario where the property is not listed, but you as a broker may have a buyer and you'd like the seller to authorize you to market the property to find a buyer to purchase this property. Seller and broker agree and understand the broker does not represent the seller in any capacity, but the broker owes the seller the no brokerage relationship duties listed in 2A, 2B, and 2C, which are dealing fairly and honestly, disclosing all known facts that materially affect the value of the property, which are not readily observable to the buyer, and accounting for all funds that are entrusted to the broker or the broker's licensee. We're scrolling down to the middle section, paragraph 3. I've got it highlighted here in my corner. We've got the big bold language regarding broker compensation. Broker compensation and/or commissions are not set by law and are fully negotiable. This notwithstanding, the seller agrees that if broker procures a buyer who is ready, willing, and able to purchase the property with whom seller enters into any contract to sell, option, or otherwise transfer the property within blank calendar days after the date of this agreement, seller is going to pay to broker the following compensation payable at the time of closing or is otherwise set forth herein. So again, broker procures a buyer who's ready, willing, and able to purchase a property within blank calendar days. There's no default provision here on the number of days. Within blank calendar days after the date of this agreement, seller is going to pay to broker the compensation, and you've got check boxes for the type of compensation, whether it's a percentage of the purchase price and maybe another dollar amount, or a fee of a dollar amount, or some other type of compensation of other. If, paragraph 4, if the seller defaults under a contract with a buyer procured by the broker, and the transaction does not close as a result of the seller's default, then the seller is going to pay the full compensation to the broker as set forth herein upon demand by the broker. Again, this is in the event of a seller getting cold feet at closing. If the seller defaults under a sales contract or with a buyer procured by the broker, then this seller is going to be responsible for paying the full compensation to the broker. We've got paragraph 5, a retained deposits clause. Paragraph 5, if any deposits paid by a buyer procured by broker are retained by the seller following a termination of the contract, then blank percentage, and if blank, then 50% of that deposit amount, but not exceeding the full amount of unpaid compensation, will be paid to the broker by seller as full consideration for the broker services, and the balance will be retained by the seller. So again, this is in the event of perhaps a buyer defaulting, seller gets to keep the buyer's deposit, for example. There's a retained deposits clause that allows a portion of that deposit amount to be paid to the broker as consideration for broker services. All right. Go with me down to paragraph 8, just in connection with litigation concerning this agreement, venues in the county where the property is located, and the prevailing party will be entitled to cover attorney's fees and court costs, including on appeals from the non-prevailing party. That language is similar as it exists in our other agreements. All right, I'm going to show you now our the clean version of the showing agreement, just so you can see it's much easier to read here. We've got paragraphs 1 through 5 here, just what our sellers are going to see. They're going to allow the broker to show or market the property for a purchase price of blank. Paragraph 2 has our no brokerage relationship disclosure language. Paragraph 3 talks about broker compensation. It is not set by law and is fully negotiable. And having the seller agree that if broker procures a buyer within blank calendar days after this agreement, seller is going to pay broker compensation. We get to define and negotiate that type of compensation the seller is agreeing to pay the broker. And paragraph 4, we understand if the seller defaults under the contract, they would still be required to pay compensation to the listing broker on this, or the broker in this agreement. Paragraph 5, in the event of a buyer default and the seller gets to keep the buyer's deposit, then there's a retained deposits clause where you can negotiate how much of that deposit would be paid to the broker from the seller. All right, we are moving right along. The next form that we have is the broker compensation agreement. This is a brand new form, brand new, created for the purpose of documenting the agreement between a listing broker and a buyer's broker for that listing broker to pay a portion of the compensation that is being collected under that listing agreement to the buyer's broker. So it's, again, an agreement between our listing broker and our buyer's broker documenting what we used to see on MLS. Now we don't see offers of compensation on MLS. There are no MLS fields in our MLS, compensation fields in our MLS anymore. So this is the documentation between the listing broker and the buyer's broker for offering compensation, and there would be an agreement upon receipt of the listing broker of the total compensation under their listing agreement. Buyer's broker would be compensated a portion as negotiated herein. So signed between the listing broker and the buyer's broker related to this particular property address. And they agree with respect to the following buyer. Insert your buyer or buyer's name. Paragraph 1 is just sort of an explanatory listing broker has entered into a listing contract with the seller of the property in order for listing broker to provide brokerage services to the seller, whereby the seller has allowed the seller or the listing broker to provide compensation to a buyer's broker for procuring a buyer. Paragraph 2, here's where the listing broker is committing to compensate the buyer's broker. Listing broker agrees to pay the buyer's broker compensation equivalent to the following: a percentage of the purchase price plus some dollar amount, a fee of some dollar amount, or some other type of compensation, provided that the sale transaction of the property closes with that particular buyer listed in this agreement during the term of the listing contract or any extension or protection period thereof, and the buyer's broker listed on this form is the procuring cause of the sale of the property to the buyer. This compensation, paragraph 3, the compensation due to the buyer's broker under the terms and conditions of this buyer broker compensation agreement will be paid by the listing broker at closing. So we have the who, listing broker to buyer broker, the what, compensation listed in paragraph 2. Whatever it is that the listing broker is authorized to offer to compensate the buyer's broker, you'll put that information there. And we know when that will be paid. The compensation due to the buyer's broker under this agreement will be paid by the listing broker at closing. Paragraph 4, no modification of any terms of this agreement will be binding unless the modification is made in writing and signed by both parties. Just as with any contract, we can't unilaterally modify, but we can modify with buyer's broker and listing broker's agreement. If they both sign an amendment to this form, then they can modify the terms of this agreement. Paragraph 5, regarding dispute resolution, any controversy or claim arising out of or related to this agreement or the breach thereof will be submitted to arbitration to the extent required pursuant to arbitration procedures of the National Association of Realtors and a member board of the National Association of Realtors having appropriate jurisdiction to conduct arbitration proceedings. Again, disputes between brokers, to the extent required, arbitrated. All right, paragraph 6. The listing broker and the buyer's broker each further acknowledge that their respective customer has also been provided a copy of this agreement and agreed to the compensation set forth above, and big bold language, real estate broker or any brokerage compensation is not set by law and is fully negotiable. So we want to touch in paragraph 6 just a little bit more. Remember that one of the outcomes, one of the lessons we need to learn from the settlement is to promote transparency. So transparency related to compensation and negotiability, right? Transparency meaning we are going to let both buyer and seller know what the total compensation is due to both brokers, and compensation, if it's going from a listing broker to a buyer's broker, the buyer and seller are entitled to a copy of this agreement. So both brokers here are saying, yes, we provided a copy to our customer of this agreement. So again, the negotiability, big bold language, you'll see it in almost all of the forms that real estate broker and any broker compensation agreement, compensation is not set by law and is fully negotiable. Okay, who's going to sign this form? The listing broker or authorized listing broker's signature. So again, you're going to have a conversation with your listing broker as to who can sign these forms to bind the brokerage. Sometimes that is a licensee who is authorized to sign these forms. Sometimes it will solely be the qualified broker. Sometimes it will be a broker manager. So you need to have the conversation with your broker as to who should be signing these forms on behalf of the brokerage. Signed by a listing broker, signed by a buyer's broker, and that's that. So this, again, this form, compensation agreement between brokers to document the agreement by a listing broker to pay a buyer's broker compensation, provided that that listing broker in their listing agreement with the seller elected to pay buyer broker compensation. This is how we're going to document that between the parties. All right. The last form in packet number 1 is the new construction disclosure, new construction compensation or broker disclosure form. We removed the word compensation because you'll still need a buyer broker agreement. Even if you're selling new construction, you are a realtor, you will need a buyer broker agreement. This is just related to some of the services that a buyer broker may offer to a buyer when dealing with new construction. Again, this is a form that has existed in the library for a while. We just removed some of the language in paragraph 1, defined buyer's broker, and added at the very bottom of the page, the compensation and or any broker commissions are not set by law and are fully negotiable. Okay, as I switch gears into the second packet, we're going to be moving into the second packet of forms. I do want to make sure that I bring up the contact information, the NABOR legal hotline. If you call the NABOR legal hotline, you will be directed to one of the attorneys who serves on the Legal Resources Committee. If you have any questions regarding the Florida Realtors Forum, we've got the Florida Realtors legal hotline available as well. And if you have any specific questions regarding the forms that we've discussed today or suggestions regarding the forms or any of the forms in the NABOR library, you can send an email to marty@nabor.com. Just again, in the subject, so he knows where the question is coming from, reference the contract changes in that subject. Okay, I am going to pull up the second packet. The first form in the second packet is the amendment to the listing contract regarding compensation and concessions. So I do want to read a couple preliminary notes before we go into the details of this. We know that there were some requirements regarding disclosures pursuant to the NAR settlement, including a disclosure in conspicuous language that the broker commissions are not set by law and are fully negotiable, and also a disclosure and seller approval for any payment or offer of payments that a listing broker may make to a buyer's broker or agent of some other representative acting for the buyers. So we've created two forms for this purpose to be used with existing listing agreements. Brokers electing to use these forms should review their existing listing contracts and make their own determination as to which form is appropriate for the circumstances of their current listing contract. The first form we're going to talk about is the amendment to listing contract. Note that this form, if you see in the big red language, this form is intended to be used only with NABOR listing contract forms with a copyright date on or before October 1st, 2022. So again, if you've got a current listing that with a copyright date of on or before October 1st, 2022, you can use this amendment to listing contract. And the second form is the broker compensation disclosure. I would encourage you to have a conversation with your broker as to which form and how they would like you to use these forms. Again, we provide tools. It is up to your broker and broker's counsel as to which form you should use. If you ever have any questions regarding the language in the settlement, I can put in the chat the link to the NAR settlement FAQ. And these forms in this second packet, as I mentioned, are available on the NABOR website. They have been provided to your contract vendors. Each vendor has their own timeline with respect to uploading them into the system, but just keep checking the NABOR.com site. We have a section at the very top where all of the revised forms will live. And this first form that we're going to talk about currently exists on on the NABOR.com website, even if it doesn't exist in your form simplicity or app files or .loop. Okay, this is the amendment to listing contract. And because we already have an amendment to listing contract in our old forms library, this one is different because it deals with compensation and concessions. So that is the name of the form. We're referencing an MLS number, and we're saying this amendment to listing contract dated blank. I'm going to put the date of your original listing contract between the seller and the broker regarding a particular property. Again, because this is a new form, we don't have to deal with the messy red lines. We can just go straight into the form itself. I'm in Roman numeral 1, broker compensation. Let's rewind. An amendment to contract amends or revises something that has already been executed, right? So we're saying for good and valuable consideration, this listing contract is amended as follows. Subparagraph 1 regarding broker compensation. We're saying paragraph 4K3 is hereby deleted in its entirety on that original listing agreement and replaced with the following. Broker has explained to the seller that if seller offers to compensate broker who's procured the buyer, such broker compensation will be deducted from the total compensation due to the listing broker, with the listing broker retaining the balance of the compensation to be paid by the seller as set forth herein. Also, buyers, agents, and brokers, even if compensated by the broker or seller, may represent the interest of a buyer. Subparagraph 3, that a buyer broker compensation is not set by law, is fully negotiable. Seller is not required to make an offer of compensation to buyers, brokers, or other buyer representatives. And subparagraph D, giving the seller the option to elect to permit the broker to offer to share compensation to a buyer's broker, or subparagraph D2, does not elect to permit broker to offer a portion of the compensation to a procuring buyer's broker. So this paragraph would amend paragraph 4K3 in your listing agreement and give the seller the option to offer compensation to a buyer's broker or not elect to offer a portion of the compensation to a buyer's broker. All right, subparagraph 1.3e Brokers offer to compensate other brokers will extend to the following types of brokers. Again, you're checking all that apply, and if none are selected, then all will apply. This is where you get to check the box of the type of brokers that the sellers offer to compensate a buyer's broker if they have a transaction broker, single agent, or no brokerage relationship. That's subparagraph 1 in this amendment regarding compensation and concessions. Subparagraph 2, multiple listing services, MLS. It's notifying the seller that offers of compensation to buyer's brokers or other buyer representatives will no longer be displayed in the MLS. This is the disclosure for our sellers who entered into a listing agreement months ago that offers of compensation to buyer's brokers will no longer be displayed in the MLS. Subparagraph 3 regarding sellers' concessions. Remember, our original listing agreements did not, so for the form October 1st, 2022, that form did not have a section regarding seller concessions. So now if the seller would like to offer a concession to a buyer, we've got subparagraph 3. This language and the language above it is exactly what appears in our listing agreement, now our newly revised listing agreement. So seller does not elect to offer compensation or a concession to a buyer, or does elect to offer a concession to a buyer, and the amount of blank dollars or blank % of the purchase price towards the buyer's closing costs and prepaid, which may include the payment of compensation to a buyer's broker. We're defining that as a seller's concession. Again, our previous listing agreement did not have a provision to offer seller concession. This amendment to contract does that. Amendment to listing contract does that. If no selection is made, does not, shall apply. And we have, of course, the big bold language that notes that broker compensation is not set by law or policy and is always fully negotiable. You'll see that disclosure everywhere. Roman numeral 4, seller sales contract obligations. Seller shall provide verification of and pay any buyer's broker compensation and pay any seller concession to buyer if elected. Again, if the seller agrees to pay buyer broker compensation, they're going to be providing verification of their agreement and, of course, pay the seller concession to the buyer if they elect to do so at closing. Other terms, you and this amendment to listing agreement have the opportunity to amend other terms in the original listing agreement. Again, anytime I see a blank line, I have a little flag that says maybe discuss with broker, discuss with counsel before you sign on behalf of your brokerage, but there is a provision for other terms. All other terms and conditions of the listing contract will remain in full force and effect. And we've got the big bold language regarding broker compensation disclosure. Compensation paid to a real estate broker and or any broker commissions are not set by law and are fully negotiable. This will be signed by our sellers and the authorized broker's signature. Again, if this is a licensee who's authorized to sign on behalf of the broker, great. Double check with your broker whether you're authorized to sign or whether these need to be signed by your broker. Okay. Moving into the second document of the new packet, the second packet is a broker compensation disclosure. This has our seller name regarding the following described real property. And again, this is for sellers who are already under a listing contract. Has some language, I'm going to maybe make it a little bit larger so we can see it on our screen. As part of the proposed settlement by NAR of certain class action lawsuits, the Naples Area Board of Realtors and MLS of Naples implemented changes required by the settlement that preserve choices consumers have regarding real estate services and which provide greater transparency related to broker compensation. The middle provisions highlight 2 of those key changes. Number 1, that offers of compensation to buyers brokers are prohibited from being displayed in the MLS. And as of August 1st, all offers of compensation on current listings will no longer be displayed in the MLS. Also, number 2, as of August 17th, all buyers brokers working with the buyer must enter into a written agreement that specifies the amount of compensation paid to a buyer's broker before the buyer tours any home. So we're just letting our parties know this, these changes exist. These changes affect all real estate brokerages that are MLS participants. They do not restrict sellers from making offers of compensation to a buyer's broker. Sellers and listing brokers may offer compensation to a buyer's brokers, but such offers must not be displayed or referenced in the MLS, And sellers may indicate their willingness to offer a concession to a buyer in the MLS, but that language is very restricted. So seller offers concession, very restricted. We're not including dollar amounts in the MLS. Okay. If the seller's current listing contract with the broker authorizes the broker to make an offer of compensation to a buyer's broker that procures a buyer and/or requires the display of any such offer of compensation to a buyer's broker that procures a buyer in the MLS, then this disclosure will constitute an amendment to that listing contract whereby the seller elects to permit the broker to make an offer of compensation to a buyer's broker that procures a buyer to the extent set forth in the listing contract. And the seller further acknowledges that any offer of compensation to a buyer's broker may no longer be displayed in the MLS. However, the broker may make offers of compensation to buyer's brokers through the broker's website or other means permitted by applicable MLS rules. So again, offers of compensation to a buyer's broker can exist outside of the MLS. They cannot exist inside the MLS. And we're putting our sellers on notice that offers of compensation, if they were offered prior to August 1st, they are no longer going to be displayed, or they're no longer displayed on MLS. Got a big bold compensation disclosure language as well. This will be signed by the seller's authorized broker's signature and the licensee name here as well. Again, brand new form, broker compensation disclosure. We've got the other form is the amendment to the listing contract regarding compensation and concessions. Discuss with your broker what you'd like to use for the time being, where you've got listings that were executed on a listing agreement for NABOR with a copyright date of October 1st, 2022 or before. Moving into the future, we've got the amendment to broker compensation agreement. Remember how I said that broker compensation form is the agreement between the listing broker and the buyer's broker as to compensation, because that offer of compensation is no longer going to be displayed on MLS. You would have a broker compensation agreement executed between the listing broker and the buyer's broker. To the extent that the brokers want to modify that agreement, we have an amendment to broker compensation agreement here. It's a form with a lot of blank space. Again, before you bind your brokerage to something, make sure you're getting that approved by counsel or by your broker. It should be signed by the authorized broker or whoever is authorized to sign documents on behalf of your brokerage. Okay. The next form is the addendum to sales contract regarding concessions. So the previous forms were broker forms between listing broker and buyer's broker, between listing broker and seller, between buyer and buyer's broker. This is the form called an addendum to sales contract related to concessions. We did not previously have any addenda related to credits or concessions, so we have this form that was recently approved by Legal Resources to allow you to check a particular box and fill in the blank rather than create language related to concessions. So this is an addendum to the sales contract entered into between seller and buyer related to the following described real property. We've got other terms and conditions. Seller shall provide a credit to the buyer at closing as follows. You get to check the box whether the buyer, if you're making the offer, the buyer is asking the seller to provide a credit. Check the first box, credit in the amount of dollar amount or percentage of the purchase price towards closing costs and prepaid, and or a credit in the amount of blank dollars or percentage of the purchase price towards buyer's broker's compensation, or some other credit or offer of something from seller to buyer. So again, this is an addendum to contract related to concessions. Seller shall provide a credit to buyer at closing as follows. You've got the option for a credit amount of blank dollars towards closing costs and prepaid, blank dollars towards buyer's broker's compensation, or some other compensation agreement here. And just a quick note, the reason these are split out here with respect to closing costs and prepaids or broker's compensation is in the event that it is a finance transaction and the lender needs to see what portion of the credit may be going towards buyer broker compensation. That's important to kind of break them out here. So the seller could elect to pay none of this The seller could elect to pay just a credit towards closing costs and prepaids, or the seller could elect to pay a credit that could go towards buyer's broker's compensation. This would be executed by buyer and seller. And we've got the big bold language again, that compensation paid to a real estate broker and or any broker's commissions are not set by law and are fully negotiable. So in no event will compensation paid to a buyer's broker exceed the amount of compensation agreed to in a buyer broker agreement or other representation agreement here. Okay, we did go through all of the forms. I do want to do a quick recap for you as well. And I know I'm going to put on the screen where we can send in some questions to Marty at NABOR.com. You're welcome to call in the NABOR legal hotline, and we can kind of talk about what's happening with legal resources. So quick recap, some of the forms that you've seen today were already in the library. They were just revised to meet the new challenges that we have in our industry. Some of them are brand new forms. So please don't let this presentation today be the only time you're reviewing the forms. Sit down with them, review them at your leisure. It's easier, I think, to review the clean copies of the forms than the red line versions. But review those forms, make sure you understand its terms. If you don't understand any of the terms of the forms, consult with your broker, consult with Brokers Council, contact Marty at NABOR.com, contact the NABOR legal hotline, contact the Florida Realtors legal hotline with respect to any of the Florida Realtors forms or are compliant. I'll also put in the chat the NAR settlement FAQ link. I'm going to go ahead and drop that in as well. What else is a good source of information is the Florida Realtors site. So you can see where the Florida Realtors forms are updated pretty frequently. Bear with me a second, I will put that up as well. And then let me recap real quick the forms that we reviewed today, and we'll talk about what's on the horizon for the balance of the NABOR forms. Okay. Oh, yeah. No, now I've done it, you guys. Let me try again. Okay, so I will recap the forms that we just talked about and talk about what is coming down the pipeline. First, the first packet that we talked about was the listing agreement that has been revised. What we didn't talk about today was the listing agreement for vacant lands that has also been revised with all of the similar changes that we saw on the listing agreement for improved property. So know when you pull up that form from NABOR.com, that has also been updated to reflect all the exact same changes, vacant land listing and residential improved listing. That buyer broker agreement exclusive, that form already existed in the library, has been updated. The amendment to that buyer broker agreement, again, consult with counsel and your broker as to the information that you can amend in your buyer broker agreement. That showing compensation agreement is with respect to, let's say, a for sale by owner, but you would like to be compensated by the seller with a no brokerage relationship or no agency relationship. But if you procure a buyer, you'd like to be compensated by the seller. We've got the broker compensation agreement. Remember, that is replacing those offers of compensation that appeared on the MLS. We know offers of compensation no longer appear on the MLS. So in order to have the documentation between the listing broker and the buyer's broker with respect to compensation that may be offered by the listing broker to the buyer's broker as set forth in the listing agreement, you need this broker compensation agreement executed by the brokers or the authorized parties on behalf of the brokers. We've also got the new construction broker services disclosure form. Again, with that form, you will still need a buyer broker agreement to comply with the terms of the settlement, but this just sets forth some of the services that you as a broker may perform on behalf of a buyer in the event of a purchase of new construction. The second packet that we talked about was a set of brand new forms. The first was the amendment to the listing contract regarding compensation and concessions, and the second document was the broker compensation disclosure. Those two forms are intended to notify our current sellers who are currently under listing agreements under a NABOR listing agreement dated October 1st, 2022, that copyright date, to inform the seller of a few things. One, that MLS offers of compensation will no longer be listed in the MLS. Two, that offers of compensation to a buyer's broker are not required, that compensation is negotiable, that buyers will be required to enter into buyer-broker agreements before they tour a property, and the amendment to listing agreement, again, related to compensation and concessions, offer the seller the opportunity to offer a credit to a buyer, a concession to a buyer. Number 3 on that second packet was the amendment to the broker compensation agreement. Again, let's say that between the listing broker and the buyer's broker, the offer of compensation is X, but maybe that buyer agent is only able to accept Y. You may need that amendment to the broker compensation agreement between listing broker and buyer broker to reflect the actual amount of compensation that that buyer broker is entitled to receive. And then finally, the maybe newest and most exciting form for your sales contract is the addendum to sales contract related to concessions. It is an addendum to contract. You're going to need to check the box under the addendum section and reference that addendum to sales contract concession to make sure it is incorporated into your contract. So remember, we've got a sales contract and our sales contract. In the addendum section, if the version of the contract form that you have doesn't have a checkbox yet for addendum to sales contract for concessions, go ahead and check the box for other addenda and write in addendum for concessions and attach that addendum to contract related to concessions to your sales contract. Make sure you check the box and attach. Very important there. And again, you've got options under that addendum related to concessions to offer a credit from seller to buyer at closing towards closing costs and prepaids, or a credit from seller to buyer related to that could go towards buyer broker compensation, again, negotiated in your sales contract. And that is all of the forms. This is a rarity that I finished slightly early, but I do want to make sure that you have, while you're here, that you have a chance to make sure you write down your questions.
I send you a chat. Can you read it to them? Because that's something they can use as well.
Absolutely. Yes. Let's see. Yeah. So may share specific content provided on Facts.Realtor, but also advise you to visit Facts.Realtor for the most up-to-date information or talk to your broker. Also, I'm going to include in the chat the Florida Realtors site that almost every day that I look at the site, there's something new there. So the last time it was updated, in fact, this was updated today on Florida Realtors. I'm going to put that in our chat as well. Bear with me just a moment. Again, this is where you'll see the most up-to-date Florida Realtors forms. If you haven't attended any of the Florida Realtors related classes, please do. Some of them are available now for replay. NABOR will have a number of in-person classes. Again, as we get more information, as we revise additional forms, we will provide that information to you. Also, just know, coming down the pipeline, there will be revisions to the NABOR sales contract. Before you freak out, just know it is on the very last page of that sales contract where it references offers of compensation on the MLS. That provision has been stricken from the sales contract. So when you're looking at the NABOR sales contract forms for future use, make sure if they're available on NABOR.com website, that will be the most up-to-date form to use. The all 3 versions of the sales contracts will be updated with that provision, and also including a checkbox for adding concessions, adding that addendum to contract related to concessions. And in the works are every form in the NABOR forms library that references cooperating broker or seller's broker, cooperating broker and selling broker. Those words are going to be changed to buyer's broker. If the document relates to compensation, it will also have the big bold language regarding broker compensation disclosure. So those things are in the pipeline. Again, keep checking back on NABOR.com's website where you can receive the most up-to-date NABOR contract forms. As the vendors receive the updates, they will also push them out. But as you can imagine, if the vendors work with multiple associations and they have multiple sets of documents to update, they may be a little bit slower. So the best place to get the most up-to-date forms would be on NABOR.com. Hop in and get those up-to-date forms. And yeah, if you have any questions, you feel free to, you can reach out to me, you can reach out to Marty. I know we've got some other in-person classes coming up. I think we've got one on August 14th. I think might be in person. Anyway, so I look forward to the opportunity to work with you. If you're working with these forms and you find that there's something that you would really like to see in the NABOR library, let us know. We are very open to these suggestions. We are in a revision year of the NABOR contract. Every 2 years, the NABOR Legal Resources Committee convenes to take your suggestions, take suggestions from real estate practitioners here in Southwest Florida to modify and improve the NABOR contract forms. So if you have any suggestions that are not related to these revisions, I bet you've already submitted them over to Marty, and we're probably going to be talking about them very, very soon. Otherwise, if you have any suggestions related to these contract changes, or there's something you think that we're missing, let us know, and we are happy to accommodate. And I'm sorry we didn't get to take questions today, but again, send your questions by email, and I promise you Legal Resources will address them with you directly. And
Definitely
that's all
will.
I've got for today.
Thank you so much, Erin. Appreciate you.